Hello and welcome to Point 1. 6 minutes of ethics a day could keep the legal malpractice claims away. Could, no guarantees of course. Today we're going to be talking about New York State Bar Association Ethics Opinion 1131, which touches on a lot of rules. Big opinion. Rules 1.0, 1.5, 5.4, 7.1, 7.2, and 7.3. And this opinion specifically overrules New York State Opinion 902 from 2012, which had to do with the payment of the marketing fee. The questions presented to the committee were whether a pay-for-profit company that maintains an internet-based service, the opinion defines as the service, whether the website constitutes an advertisement by or on behalf of the lawyer for which the lawyer is responsible under the rules. Also, does the lawyer's payment to the service for the names of potential clients constitute an impermissible payment for obtaining employment? And if the lawyer can use the service, does the lawyer's outreach to a potential client constitute an impermissible solicitation or advertisement within the meaning of the rules? So we've got an internet-based website referral service, and the lawyer pays. We'll get to the facts. Jumping down to the conclusion, the lawyer can use the pay-for-profit service as long as transparent and mechanical methods are used to assign the attorneys, and that the service does not purport to use any analysis of the potential client's legal problems or the qualifications of the selected lawyers. We've seen in prior ethics opinions that's the problem. Picking the best or the right lawyer is a problem. And that the service does not explicitly or implicitly recommend any lawyer specifically, and that the website otherwise complies with the requirements of Rule 7.1. A lawyer who has purchased such a lead may telephone the potential client if the client has invited a telephonic communication by the lawyer through the service, which it turns out is the case here. So the facts. A lawyer wishes to pay for use of the service. Those potential clients who wish to be contacted by the lawyer submit their names, contact information, how they can be contacted, telephone in some cases, the geographic location, and the practice area they're looking for advice in. The service uses its database of attorneys to identify all the lawyers in the state engaged in that practice area and that locale. The service uses a neutral mechanical criteria to connect the potential client to lawyers, and the selection method is clearly described to potential clients. The service forwards the potential client's information to the lawyer that is brought up. And the mechanical nature is the first lawyer to register gets the first lead, the second lawyer to register gets the second lead, and so on until the database recycles. So there's no, there's no endorsement that this is the right lawyer for this potential client. The participating lawyer pays a fixed monthly fee to the service. The fees do not vary on whether the lead results in retention of the lawyer or the amount of fee that the lawyer charges or anything like that. It's just a flat monthly fee, which I think is important here. And if the potential client decides not to retain the lawyer, or if the assigned lawyer has a conflict of interest or for any other reason can't represent the potential client can go back to the service and get another lawyer through the assignment system. So the opinion, this is a long opinion. Gonna have to rush through it to stay within our point one. The opinion specifically notes that there's a lot of internet out there, and so this opinion doesn't attempt to address every factual permutation that may exist, which may be a bit unnecessary, but good to think about at first. The opinion also does not address whether the service would implicate Judiciary Law Section 495, which says that no corporation shall furnish attorneys or counsel, which is a question of law that the committee is not addressing. So diving in. The prior committee opinions 779 and 799 are addressed at the outset. And in 779, a lawyer wanted to pay a marketing organization a fee in return for a bundle of pre-screened potential clients dealing with tax issues. And under the old Code of Professional Responsibility, the committee concluded that accepting leads in this fashion was not permissible under Disciplinary Rule 2-103B, which said a lawyer can't compensate or give anything of value to a person to recommend or obtain employment. Now, in Opinion 799, the committee addressed whether a lawyer could pay to participate in a website that forwarded inquiries from potential clients to lawyers, who then the lawyers would contact the potential client, where the service purported to analyze the client's problems and connect a lawyer based on the client's problems. And the committee noted the issue there is that it's not permissible to recommend an attorney to analyze for a non-legal service to analyze legal problems and recommend an attorney based on those options. And then finally, in opinion 902, the committee dealt with whether a lawyer could pay a marketing company a fixed fee each time the marketer made an introduction to a potential client. And the committee found that that was also impermissible. Again, all three of these, 779, 799, and 902, all three of those opinions were dealing with the old rules, and specifically Disciplinary Rule 2-103B. So, jumping into the modern rules, Rule 7.1 governs advertisements, and Rule 1.0A defines advertisement as any public or private communication made by or on behalf of a lawyer or law firm about that lawyer or law firm services, the primary purpose of which is the retention of the lawyer or the law firm. And of course, that primary purpose is the key.